Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of constitution, that too in relation to matters questioning validity of section 3(2) of the Benami Transactions Prohibition Act 1988. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hi everyone, today I'll be discussing a latest Supreme Court judgment with you all. So in the important judgment titled Union of India and Others versus GANPATI DEALCOM Private Limited, which was pronounced on 23rd August 2022, the Supreme Court has held that Section 3 Clause 2 of the Benami Transactions Prohibition Act 1988 as unconstitutional on the ground of being manifestly arbitrary. The facts of the case would be that the respondent company purchased a property in its name from various sellers. The adjudicating authority issued a notice to the respondent invoking Section 24 Clause 1 of the Benami Transactions Prohibition Amendment Act 2016 to show cause as to why the aforesaid property should not be considered as Benami property and the respondent as Benamidar within the meaning of Section 2 Clause 8 of the 2016 Act. Thereafter, the adjudicating authority passed an order under Section 24 Clause 4 Subclause B Subclause 1 of the 2016 Act, provisionally attaching the property. Being aggrieved, the respondent filed a writ petition before the Calcutta High Court, and the same was disposed of by the single judge with a direction to the adjudicating authority to conclude the proceedings within 12 weeks. On appeal, the High Court, while quashing the show cause notice, held that the 2016 Act does not have retrospective application, and aggrieved by the aforesaid impugned order, the Union of India is in appeal before the court. The short legal question which arises for the consideration is whether the 1988 Act as amended by the 2016 Act has a prospective effect. To put it differently, whether Section 3 Subclause 1 and Chapter 4 read with Section 5 of 2016 Act have retrospective effect or not. The Supreme Court has held that Section 3 Clause 1 of 1988 Act is vague and arbitrary. Section 3 Clause 1 of 1988 Act created an unduly harsh law against settled principles of law commission recommendations. Section 5 of 1988 Act, the provision relating to civil forfeiture, was manifestly arbitrary. Both provisions were unworkable, as a matter of fact, were never implemented. As Section 3 and 5 were held to be unconstitutional under the 1988 Act, it would mean that the 2016 amendments were creating new provisions and new offences. Therefore, there was no question of retrospective application for the 2016 Act. As for the offence under Section 3 Clause 1, for those transactions that were entered into between 5/9/1988 to 25/10/2016, the law cannot retrospectively invalidate a stillborn criminal offence as established. The offence under the provisions of Section 53 of the 2016 Act is prospective and only applied to those transactions that were entered into after the amendment came into force, which is 25/10/2016. Any contrary interpretation of Section 3 of the 1988 Act would be violative of Article 20 Clause 1 of the Constitution, which deals with protection in respect to conviction of offences. The 2016 Act containing the criminal provisions is applicable only prospectively, as the relevant sections of the pre-amended 1988 Act containing the penal provisions declared as unconstitutional. Therefore, the question of construction of the 2016 Act as retrospective qua the penal provisions under Sections 3 or 53 does not arise. Although Section 5 of the 1988 Act was held to be unconstitutional for being manifestly arbitrary, however, such holding is of no consequence if it is concluded that the confiscation under Section 5 of the 2016 Act, read with Chapter 4, was civil in nature and is not punitive. The legislature has power to enact retrospective civil legislations under the Constitution. However, Article 20 Clause 1 mandates that no law mandating a punitive provision can be enacted retrospectively. Further, a punitive provision cannot be couched as a civil provision to bypass the mandate under Article 20 Clause 1, which follows the settled legal principle that what cannot be done directly can also not be done indirectly. Acquisition under the earlier 1988 Act as well as the confiscation under the 2016 Act are said to have been enacted on a reasoning that the property emanating from the Benami transaction also gets tainted. The substantive difference between the acquisition provision under the earlier enactment and the confiscation provision under the 2016 Act is that proceeds of Benami transactions have been made traceable under the 2016 Act. Further, under the Indian Penal Code, forfeiture is recommended to be a form of punishment under Section 53. Accordingly, the Criminal Procedure Code provides for a mechanism for interim custody and forfeiture at the conclusion of trial under Section 451 of the Criminal Procedure Code, which reads as order for custody and disposal of property pending trial in certain cases. The 2016 Act contemplates an in rem forfeiture wherein the taint of entering into such a Benami transaction is transposed to the asset itself and the same becomes liable to confiscation. At the cost of repetition, it may be noted that the taint of Benami transactions is not restricted to the person who is entering into the aforesaid transaction. Rather, it attaches itself to the property perpetually and extends itself to all the proceeds arising from such property unless the defense of innocent ownership is established under Section 27 Clause 2 of the 2016 Act. When such a taint is being created not on the individual but on the property itself, a retrospective law would characterize itself as punitive for condemning the proceeds of sale, which may also involve legitimate means of addition to wealth. In view of the fact that this court has already held that the criminal provisions under the Act of 1988 were arbitrary and incapable of application, the law through the 2016 amendment could not retrospectively apply for confiscation of those transactions entered into between 5/9/1988 to 25/10/2016, as the same would be tantamount to punitive punishment in the absence of any other form of punishment. It is this unique circumstance that confiscation contemplated under the period between 5/9/1988 and 25/10/2016 would characterize itself as punitive if such confiscation is allowed retrospectively. Usually, when confiscation is enforced retrospectively, the logical reason for accepting such an action would be that the continuation of such a property or instrument would be dangerous for the community to be left free in circulation. Further, the continuation of only the civil provisions under Section 4 etc. would mean that the legislative intention was to ensure that the ostensible owner would continue to have full ownership over the property without allowing the real owner to interfere with the rights of the Benamidar. If that would be the case, then without effect any enforcement proceedings for a long span of time, the rights that have crystallized since 1988 would be in jeopardy. Such implied intrusion into the right of property cannot be permitted to operate retrospectively, as that would be unduly harsh and arbitrary. Therefore, Section 3 Clause 2 of the unamended 1988 Act is declared as unconstitutional for being manifestly arbitrary. Accordingly, Section 3 Clause 2 of the 2016 Act is also unconstitutional as it is violative of Article 20 Clause 1 of the Indian Constitution. In rem forfeiture, provision under Section 5 of the unamended Act of 1988 prior to the 2016 amendment, Act was unconstitutional for being manifestly arbitrary. The 2016 Amendment Act was not merely procedural, rather prescribed substantive provisions. In rem forfeiture provisions under Section 5 of the 2016 Act, being punitive in nature, can only be applied prospectively and not retrospectively. Concerned authorities cannot initiate or continue criminal prosecution or confiscation proceedings for transactions entered into prior to the coming into force of the 2016 Act, which is 2510-2016. As a consequence of the above declaration, all such prosecutions or confiscation proceedings shall stand quashed. So that's it for today. Just in case you have any confusion, you guys can comment below the video, and hope you'll find this video helpful. Thank you.